In the previous lesson, we talked about the ways in which and the process by which a trust in land has to be created expressly. We talked about the concept and the creation of an express trust in land as cited by the Law of Property Act, the declaration to establish an express trust in land. In this video, we're going to talk about the trusts in land which are slightly more common in terms of that are at issue for those of you who are studying land law, which is the idea of an implied trust of land. We'll talk about what the statutes and the statute law says about this particular area, as well as look at a couple of cases that examine this in more detail. So, like I said, the previous lesson explored the express creation and regulation of trusts of land. This lesson is going to talk about how a trust of land may be established impliedly. So, according to Section 53, subsection 2 of the 1925 Law of Property Act, there will not be a necessity, there is not the necessity, for the formalities in creation of an implied trust in a similar way to that exists when we look at an express trust. If you remember back to the previous lesson, we spoke briefly about the Law of Property Act and the provisions which essentially require there to be certain formalities in place in order for there to exist an express trust in the land. Section 53, subsection 2, however, of the Law of Property Act from 1925 says something different. They say that this section does not affect the creation or operation of resulting, implied, or constructive trusts. And so, ultimately, when we think about the various different types of trust in land which may be impliedly created, one of the most common of these is this idea of a resulting trust in land, where there is another party who has contributed to the asking price of a property, even if they are not specifically the legal title owner of said property. The legal title owner of said property may have to hold on trust for those who have contributed to the asking price. This is known as a resulting trust in land. So this is in relation to the proportion of their contribution. Okay, we'll get to how this is established in the case of Dyer and Dyer in a second, but ultimately this is really where we see the majority of resulting trust in land be established. You have two people. In a lot of cases, they are in some kind of relationship or marriage. They are purchasing a matrimonial home, and often, mostly for the case of simplicity, or maybe for logistical simplicity, one of the people who is purchasing the property will put their name down and have the legal title of the property itself. They will have that legal title, but at the same time, there may still be the existence of both of these people contributing quite a significant amount to the asking price. In some cases, it could just be 50-50. And so it is held that in order to essentially represent the interests of the other person who may not be strictly holding that property on a legal basis, but they still have contributed quite significantly to the asking price, there is this view that they should have some kind of rights in equity to have an interest in that property, which is what a resulting trust of land presents. Now, the way that this is calculated, as soon as it has been shown that a resulting trust of land exists, it will be calculated on the basis of the proportions of their contribution. We see this in the case of Dyer and Dyer from 1788. Okay? This is a very old case, as you can tell. In this case, an individual had provided money for the purchase of a legal estate, which was going to be conveyanced by another person. So, a very simple transaction that exists. There was no evidence of the purchaser making a gift, and as such, it was assumed that the legal purchaser of the property would be holding that on trust for the individual who contributed to the asking price, to the purchase price. So given the fact that there was no assumption that this money that went towards the contribution of the purchase price was actually made for the purposes of a gift, it was therefore assumed that if it wasn't a gift, then it would represent a trust. It will represent the existence of a resulting trust. Of course, this speaks to one of the maxims of equity, which states that equity will not perfect an imperfect gift. So you have to be very clear when you're presenting a gift, and you do not and should not rely on equity to perfect such an imperfect gift. So this was argued in the courts, and the courts held that this was the case, that the property was actually held on trust, and that this represented a resulting trust in the property. The courts say that the trust of a legal estate, whether freehold, copyhold, or leasehold, whether taken in the names of the purchasers or other jointly, or in the names of others without that of the purchaser, whether in one name or several, whether jointly or successive, results to the man who advances the purchase money. It is this this subsequent passage in the quote that I have here that is what's most important for us to establish. Whatever the property is, the trust of a legal estate will result to the man who advances the purchase money. So if you put together the purchase money, then the resultant trust advances to you as an individual who has contributed significantly to the asking price, unless it can be shown that purchase money was actually a gift, in which case that would represent a gift, and there would not be any creation or resulting trust as a result. This gives rise to an evidentiary presumption that exists, the idea of there being a presumption of a resulting trust. The previous case assumed that there was a presumption that a resulting trust is created, where another individual has contributed to the asking price of a property. And so this is obviously an opportunity that is able to be rebutted, but at least when it comes to the evidentiary standard that the courts have set, the case of Dyer and Dyer tell us that essentially what happens here is that if another person has contributed significantly to the asking price or has contributed to the asking price of a property, there is a presumption that there is not a gift in that regard. The presumption is that it is a resulting trust that has been created, and it is up to the often the defendants or whoever is trying to argue that it is a gift, that this presumption should be rebutted, that this presumption should not exist. Now, there are a number of trust cases that result to and relate to the rebutting of the presumption of a resulting trust. These include the case from 1875 of Fawkes and Pascoe. We also have the 2016-2017 case of Patel and Misra, and we also have the Henderson and Dorset healthcare case in 2020. If you want me to go into these cases in more detail, potentially as a case summary video, I will do so in future lessons' time.